Hello friends, welcome to Citizen Justice Forum video series to empower the citizens of India. दोस्तों, आप सभी का सिटीजन जस्टिस फोरम के इस वीडियो सीरीज श्रृंखला में स्वागत है जो हर नागरिक को एम्पावर करती है। तो आज का टॉपिक है, क्या सीनियर सिटीजन गिफ्ट डीड कैंसिल करा सकता है? क्योंकि हमने अक्सर देखा है कि जब माँ बाप बूढ़े होते हैं, बुजुर्ग होते हैं, तो बच्चे लोग उनकी प्रॉपर्टी जो है वो अपने नाम पे ट्रांसफ़र करा देते हैं या गिफ्ट डीड ले लेते हैं और फिर माँ बाप को पाई पाई के लिए तरसना पड़ता है। करोड़ोंपति होते हैं, लेकिन जब उम्र ढल जाती है तभी बच्चे लोग उनका ध्यान नहीं रखते हैं और जो प्रॉपर्टी उन्होंने अपनी मेहनत से जो बनाई है, सेल्फ एक्वायर्ड प्रॉपर्टी है, वो बच्चे लोग लेके उस पर ऐश करते हैं और माँ बाप के तरफ बिल्कुल दुर्लक्ष्य करते हैं। तो इस स्थिति में सिटीजन जस्टिस एक्ट 2000 में नागरिक को क्या प्रावधान दिया है, व्हाट आर द प्रोविजंस अवेलेबल, वो आज हम देखते हैं। तो ये है सीनियर सिटीजन्स एक्ट सेक्शन 23 कैन बी एक्ट्रैक्टेड इवन if there is no condition of providing maintenance in transfer deed, says केरला हाई कोर्ट। सुप्रीम कोर्ट का ये मानना है कि गिफ्ट डीड के अंदर कंडीशंस होनी चाहिए कि अगर बच्चे लोग उनका ध्यान नहीं रखते हैं तो माँ बाप वो डीड कभी भी रिवोक कर सकते हैं। और केरला हाई कोर्ट का ये जो डिसीजन है वो मैं रीड करूँगा और आप लोग को समझाऊंगा कि किस तरह से हम सिटीजन जस्टिस एक्ट का सीनियर सिटीजन फायदा ले सकते हैं। यानी सिर्फ पैसा ही या 3,000, 5,000 या 10,000 रुपया बांधना ये कोई महत्व नहीं रखता है। जो माँ बाप ने करोड़ों रुपए की संपत्ति कमा के अपने बच्चे लोग को दी है, तो क्या वो सिर्फ 5 या 10,000 रुपया महीने के लिए मोहताज रहेंगे? नहीं। ये और एक ऑब्जर्वेशन है जो केरला हाईकोर्ट का है, एनी इमोशनल डिटैचमेंट और क्रिएशन ऑफ एन एटमॉस्फेयर as opposed to one demanded by the senior citizen would be sufficient to attract section 23 of the Senior Citizen Act. The Kerala High Court has observed that section 23 of the Maintenance and the Welfare of Parents and Senior Citizen Act can be invoked even if there was no condition of providing maintenance in the transfer deeds. Justice A. Mohammad Mustaq observed that the scheme of Senior Citizens Act is not intended to dispute the resolution but to promote measures to secure the welfare and the interest of the senior citizen and parents. Quoting verses from Kurma Purana, Manusimriti, Holy Quran and Holy Bible, the judge observed that traditional norms and values of the Indian society emphasize the duty of taking care of elders. The court observed that due to the urbanization and vast expansion in the search of livelihood, parents have been treated as a liability because of their old age and physical problem. Senior citizens do not have luxury of time, says Justice Gautam Patel and Madhav J. Jamdar of Bombay High Court. यानी क्या होता है कि अगर आज 75 साल का सीनियर सिटीजन है, वो हाई कोर्ट में केस पहुंचता है, हाई कोर्ट के अंदर फाइल करता है, तो जब तक वो केस का निकाल आएगा तब तक तो बेचारा स्वर्गवास हो जाएगा। और यही केस एक केरला हाई कोर्ट में हुआ है। सीनियर सिटीजन ने वो केस डाला था, वो अपने आप को डिपोज भी किया था कॉम्पिटेंट अथॉरिटी के सामने, लेकिन फैसला आने के पहले वो दूसरी दुनिया में चला गया था। तो explaining the difference between the adversarial legal system and the inquisitorial legal system, the court added that inquiry as contemplated under Senior Citizen Act is similar to the process adopted in an inquisitorial system, it said. अभी सीनियर सिटीजन एक्ट के लिए एक अलग से ट्रिब्यूनल बना हुआ है। वहाँ पे पहले आप कॉम्पिटेंट अथॉरिटी के पास जाएंगे और अगर आपको ये ऑर्डर से एग्रीव्ड है तो आप एपेलेट ट्रिब्यूनल में जाएंगे और एपेलेट ट्रिब्यूनल के बाद में यू विल गो टू द हाई कोर्ट। The duty of the tribunal under the Senior Citizen Act, therefore, is to elicit the truth. For that, he can refer to pleadings and evidence, but that is not decisive. The tribunal has to independently inquire into the truth and take measures to protect the well-being of the senior citizens, that is parents. The tribunal is actually not deciding any dispute in the manner as involved in an adversarial system, but is only taking measures to protect the senior citizens' parents. यानी जो कॉम्पिटेंट अथॉरिटी का जो रोल है वो टू प्रोटेक्ट द इंटरेस्ट ऑफ द सीनियर सिटीजन. The focus of the inquiry, therefore, is the protection of the senior citizens or parents as the case may be, through stages of decision taken by him at a different level. Thus, I make it clear in the light of the legislative intent assimilated on philosophical reasoning, the narrative as aforereferred, that the scheme of the Senior Citizen Act is not intended for dispute resolution, but to promote measures to secure the welfare and interests of the senior citizens and parents through measures such as demanding an inquiry under the Act as in an investigation to protect well-being of the senior citizens or parents in a manner prescribed therein. In adversarial litigation, the rights and the interests of both the parties will be adjudicated or decided. The tribunal must be guided by those factors that are required to protect such interests by eliciting the truth. The tribunal cannot take like a neutral umpire in an adversarial system. Considering the object of the legislation as above, the tribunal has to follow procedure for inquiry as in an inquisitorial system and not as an adversarial litigation. Irrespective of pleadings raised by the senior citizen, he has to address the grievance of senior citizens as expressed before him to elicit the truth. The court further noted that Radhamani and others versus State of Kerala 2016, it was held that there is no requirement under the law that there should be a written stipulation in the deed to effect that the transferee would maintain the transferor, the court observed. यानी केरला हाई कोर्ट का ये मानना है कि अगर मैंने गिफ्ट डीड दिया हूँ एज एन सीनियर सिटीजन टू माय चिल्ड्रन, even if I have not written the condition that he will maintain me, it is an unsaid or unwritten rule that he has to maintain the senior citizen, the children has to maintain the parents, whether there is a condition in the gift deed or transfer deed. If there is any condition or not, by law they have to maintain their parents. The scope of inquiry in a matter related to Section 23 must be related and confined to the circumstances under which the document was executed. In the light of Radhamani's judgment, the tribunal has to examine the circumstances under which the deed was executed. It is also necessary to find out whether the senior citizen expected that the transferee would provide amenities and physical needs to the transferor at the time of transfer. There may not be any written document in this regard. Normally, it has to be concluded from the human conduct and the nature of relationship and the circumstances in which such a deed was executed. Strict pleadings or evidence cannot be insisted in such proceedings. It is to be noted that the law only contemplates a breach on the part of the transferee in providing the amenities and physical needs to the transferor. It does not stipulate that the condition of providing maintenance should be part of such transfer. If love and affection were the circumstances for executing such deed, any failure on the part of the transferee to provide amenities and physical needs. I'll repeat this sentence, it's very important. If love and affection were the circumstances for executing such deed, any failure on the part of the transferee to provide amenities and physical needs to the transferor would attract grounds for revocation under Section 23. Therefore, any emotional, this is a very important line, any emotional detachment or creation of an atmosphere as opposed to the one demanded by the senior citizen would be sufficient to attract Section 23. Now I'm going to read one more judgment. The link of this order is here. I will give in the description this article's link and the order link, and there is one more order link to the order of the wealthy senior citizen Gopal Krishnan Nair. What happened with him? So this is also very important judgment where the quotes from the Bible, the quotes from the Puranas, and quotes from the Quran and Gita are embedded, because it is our Indian tradition that when we as in children are born, the parents take care of us, and when we grow up and parents get older, so as in children we have to take care of the parents. So now let's see what this order says. I'm not going to read the petitioners and respondents here. I will just go to the main part of the order, but I will provide you the link in the description box. You can read it. It's a very important judgment. This was of November 2015. An interesting question of importance arises for the consideration in this writ petition in the context of section 23 of maintenance and welfare of parents. See here the word, you have to see it very wisely, that it is maintenance. Maintenance means giving money for his food, for his medicine, for whatever daily needs. But welfare of parents does not mean that by just giving 5,000 or 10,000 a month, your job is over. Welfare has a very, very wide scope. That means you have to give them an emotional and moral support. You have to be a good children. If they want to go out on a holiday or a Sunday, you have to take them out. So this is what is required. Only just by giving 5,000-10,000 rupees a month, you do not absolve yourself that I am maintaining my parents. A Senior Citizen Act 2007, hereafter referred for the brevity, the Senior Citizen Act 2007. Late Gopal Krishnan Nair was wealthy businessman at Mumbai. Right? He was in Mumbai. He belonged to Kerala. Late Gopal Krishnan Nair approached the Maintenance Tribunal under the Senior Citizen Act 2007. His relief before the Tribunal inter alia was for declaration of settlement deed bearing 1297 of 2013, dated 3/6/2013, Bhimani sub-registrar as null and void. So whatever deed he had executed in 2013, his prayer was to declare it as null and void. The settlement deed had been executed by the late Gopal Krishnan Nair in the name of the petitioner therein. The first petitioner therein is his niece and the fourth petitioner is the nephew. The late Gopal Krishnan Nair, the remaining petitioners are the children of the first petitioner. The respondent number 6 to 9 are the widows and children of late Gopal Krishnan Nair. It appears that late Gopal Krishnan Nair came down to Kerala to settle down here after leaving his business. All immovable properties to be taken care of by his wife and children while he was in Kerala. He had a hope that he would be taken care by the petitioners. Therefore, with the hope that they would take care of him, he had executed a settlement deed referred as above. In the settlement deed, it is stated that he is executing the deed on account of love and affection, as well as on the ground that the petitioners were taking care of and maintaining Gopal Krishnan Nair in his old age. However, as per the Exhibit P1, the deed did not contain recitals providing basic amenities and basic physical needs to Gopal Krishnan Nair by the petitioner as condition of transfer. So what he did not mention that clause that if you don't maintain me, I will revoke the gift deed or the transfer deed. But even though if the clause was not mentioned in that deed, but Kerala High Court considered that. Let's see how. The tribunal revoked the settlement deed by finding that the settlement deed is liable to be revoked under Section 23 subsection 1 of Senior Citizens Act 2007. The tribunal was granted other reliefs based on the applicant of late Gopal Krishnan Nair. The tribunal passed the order 10/4/2015 Gopal Krishnan Nair passed away on 17/4/2015. So, Learned Counsel for the petitioner has raised following grounds as challenge of this court. In the absence of any situation in the settlement deed, the petitioner shall provide basic physical needs to the late Gopal Krishnan Nair. Document cannot be revoked under Section 23 of Senior Citizen Act 2007. Second point of contention was the late Gopal Krishnan Nair had executed a will bequeathing the property which was the subject matter of settlement deed. Therefore, on his death, the petitioner have become the full owners of the property and order of the tribunal has become inoperative. So now what he says, since the Gopal Krishnan Nair has died, the order in favor of Gopal Krishnan Nair has become inoperative. यानी गोपाल कृष्ण नायर का स्वर्गवास हो गया तो जो ऑर्डर ट्रिब्यूनल ने गोपाल कृष्ण नायर के फेवर में दिया था वो इनऑपरेटिव हो गया, यानी उसका हम कुछ नहीं कर सकते. The Senior Citizen Act 2007 has a pivotal role in Indian societal framework. The Act, in fact, comprehends a scheme of welfare provision for senior citizens. The Act contemplates right of senior citizen beyond the right of maintenance. The word welfare has a significant importance in the context. The welfare is defined under Section 2K as follows. Welfare means provision for food, health, care, recreation centers and other amenities necessary for senior citizen. यानी वेलफेयर का ये मेंटेनेंस एंड वेलफेयर. मेंटेनेंस इज गिविंग मनी, यानी जो उनका खर्चा आता है दवा का, फूड का, ये वो. लेकिन वेलफेयर का मतलब है यू गॉन बियॉन्ड द मेंटेनेंस, यू हैव टू टेक केयर विद लव एंड अफेक्शन. अगर उनको कहीं बाहर जाने का मन करता है, कहीं घूमने फिरने का, तो यू आर ड्यूटी बाउंड टू टेक the parents out. It is not only that you are only interested in his money and now he is old and fragile, you disown him. Section 23 of the Senior Citizen Act 2007 gives right to senior citizen to approach the tribunal to declare any transfer of property by way of gift or otherwise after the commencement of the above act as void in certain circumstances. It stipulates that such transfer must be with the condition that a transferee shall provide the basic amenities and basic physical needs to the transferor. B. Such transferee refuses or fails to provide such amenities, physical needs, therefore deed can be declared a void on fulfilling the two conditions enumerated as above. Declaring the transfer as a fraud or coercion or under undue influence, as the case may be, at the option of the transferor. The question is the case in the absence of the specific recital. ये बहुत बड़ा important question है. The question in this case is in the absence of the specific recital. यानी कोई condition नहीं डाला था. As condition referred as about in the settlement deed, whether the tribunals have power to declare transfer as void. Section 122 of Transfer of Property Act 1982, herein after referred to as the brevity of the TP Act, defines gift as a transfer of certain existing movable or immovable property made voluntary and without consideration. That is, Section 126 of TP Act makes a provision to suspend or revoke gift deed on happening of any specified event on which the donor and donee may agree. The word consideration in the context of Section 122 of TP Act only refers to monetary consideration and does not include natural love and affection. However, it cannot be revoked on mere will of donor. The gift on settlement deed on a promise to look after the donor at the old age in a transaction without any consideration. If such promise and expectation are treated to be a consideration, certainly transaction as a gift will be deemed to be void. Therefore, such conditions forming part of gift deed are also reiterated under Section 23 of Senior Citizen Act 2007. 10. Section 23 of the Senior Citizen Act 2007 does not contemplate that the condition should form part of the recital in the deed of transfer. This is very important. I am repeating this line again. Section 23 of the Senior Citizen Act does not contemplate that the condition should form part as recital in the deed of transfer. It only refers that there should be a condition for such transfer. This condition can be either express or implied. If there is no express recital in the deed, the tribunal has to look around circumstances to find out whether the conduct otherwise dispel the intention of the donor to revoke. The consideration for executing a gift deed or a settlement deed is based on human conduct and caring and conscientious. So it says caring also means just by giving money I'm not taking care. I'm just taking care of that is the monetary need. But he has some emotional need also. He has to be taken care with love and affection. Any donor in a gift deed would expect in a natural course of human conduct that the donee continues to behave in the same manner as behaved before the execution of the deed. This is also very important. The love and affection influence for execution of the deed certainly must be enduring without any barrier. The human conduct in relation to a particular relation is presumed to exist in all set of circumstances for governing relationship for those individuals. The transferee cannot be disown his own action of love and affection after the transfer comes into effect. The transfer itself being based on love and affection that would form part as a condition of the transaction for future conduct as well. Thus, in the absence of other circumstances to dispel, it must be presumed that transferor expect continuation of the care and love from the transferee, even the execution of the deed in the same manner he was taken prior to the execution of the deed. It is to be noted that special scheme in terms of Senior Citizen Act 2007 declares certain transfer as void, taking note of the fact that by taking advantage of the emotionally dependent senior citizens, relatives grab the property on the pretext of providing emotional support. So now relatives grab the property on the pretext of providing emotional support. Therefore, legislature through such a transaction could be declared as void as conduct leading to transaction was based on malice and fraud. Therefore, condition referred in the section 23 has to be understood based on the conduct of the transferee and not with reference to specific stipulation in the deed of transfer. Thus, this code is of the view that it is not necessary there should be a specific recital in the stipulation as a condition in the transfer of deed itself. This condition mentions in section 23 is only referable as a conduct of the transferee prior to and after execution of the deed of transfer. Thus, challenge based on the ground that there is no reference in the recital of the deed and that the transferee will provide basic amenities and physical needs to the transferor is no consequences. Under Section 17 of the Indian Contract Act 1872, fraud includes the promise made without any intention of performing it. Section 92 of the Evidence Act places a restriction on the admissibility of the evidence in various in the contradiction of the term of a registered document in writing. However, under second proviso to Section 92, the existence of any separate oral agreement as to any matter on which the document is silent, which is not consistent, this is in terms may be proved. Under the third proviso to Section 92, the existence of any separate oral agreement constituting a condition precedent to the attaching any obligation under any such contract, grant or disposition of the property may be proved. Thus, there is no requirement under the law that the condition as such should form part of written document. It can be implied from the circumstances of human conduct. In this case, the donor named Gopal Krishnan himself had disposed before the tribunal that he was deprived of the basic amenities and physical needs. It is to be noted that Section 23 provides a declaration of the document in certain circumstances, not merely with reference to failure of providing maintenance, but actually with reference to failure of providing basic amenities and physical needs, which may include failure to provide maintenance as well. The object of section is that the transferee is bound to provide provisions of welfare measures. Welfare measures. It is not talking about only maintenance, not monetary part. as understood as referred in the word welfare under section 2K of the Senior Citizen Act. Thus, this court finds that there is no reason to interfere with the factual findings of the tribunal. With regard to the question raised by the learned counsel for the petitioner that they were the owners of the demise of the Gopal Krishnan based on the will, this court is of the view that above claim it should be the scope of the judicial review based on challenge in relation to any other order under the Senior Citizen Act 2007. If petitioners have any independent claim based on the will executed by the late Gopal Krishnan Nair, petitioners are free to work out the remedy based on the will. It is to be noted that the party respondents also deny any right of the petition based on the will executed by the late Gopal Krishnan Nair. Therefore, leaving open the above question, this writ petition is dismissed at cost. So this is a very wonderful judgment given by the Kerala High Court. Now friends, if you see any senior citizens who are suffering by their children, we have this act, Senior Citizen Act 2007, and we are always there as a Citizen Justice Forum. We are ready to empower any citizens of India. Now, if you are watching this video for the first time, you like and subscribe and share with your contacts. Thank you for watching. Thank you for watching this video.